Welcome to the Deep Dive. This is where we take, well, a whole pile of research, articles, notes, and really boil it all down into the essentials, the most fascinating bits, helping you get informed quickly without feeling overwhelmed. Our mission, to give you those surprising facts, those crucial insights, tailored just for you. Today, we're diving into something that honestly, it impacts every single one of us, from the moment we arrive until, well, our final farewell. It's the Births and Deaths Registration Act 51 of 1992. Now, I know on the surface that sounds maybe a bit dry, like dense legal stuff, but trust me, it's fundamental. It shapes our identity, how we're officially seen. It's sort of the invisible scaffolding of our civil society. And if you're studying law, this isn't just some document, it's a cornerstone, a really foundational text for civil registration. So our mission for this deep dive, let's unpack this consolidated act. We'll look at its purpose, the key rules, the legal background, how it works in practice, and why it matters in the real world. We'll use clear language, examples, making it useful for everyone, whether you're just curious or you're one of those aspiring legal eagles. Okay, let's unpack this.
Yeah, and what's truly fascinating, I think, is how an act that seems like it's just about, simple admin paperwork
Right.
is actually so foundational to who we are as individuals, officially speaking, and how the state keeps track of everything.
It really is the silent machinery.
It confirms who we are, tracks our journey, makes sure our official existence is actually recognized.
It's incredible how something so, well, bureaucratic can hold such profound importance. At its very core, the act seems straightforward: to regulate the registration of births and deaths, and to provide for matters connected therewith. But is it really that simple? Where does the complexity, or maybe the surprising depth, come in?
That's a great question, because while the purpose sounds concise, the depth is really in how it does that regulating and, importantly, why it keeps changing.
So it's not static.
Definitely not. It was assented to back on April 26, 1992, started officially October 1st, 1992, but it's a living document. It's been amended quite a bit over the years. We know it was updated. I think the last check was March 2025. This constant evolution shows it's trying to stay relevant.
Right, society changes, the law has to keep up.
Exactly. And a really telling amendment came from Act 18 of 2010. It swapped out gendered pronouns he and him, replaced them with he or she and him or her right through the act.
Oh, interesting. A move towards inclusive language.
A clear signal, yeah,
Yeah.
reflecting broader changes. It also consolidated and got rid of older laws like the 1963 Births, Marriages, and Deaths Act. So it was a modernization effort, too.
Okay, so it's about registering events fairly and keeping it current. Given how crucial this is, who's actually in charge? Who steers this whole administrative ship?
That responsibility, it lands squarely on the Director General of Home Affairs.
Okay, the head of the department dealing with IDs, citizenship, all that.
Precisely, the central figure. The Act explicitly gives the Director General the job of administering it, and it's not just a title. While the DG can delegate tasks, specific duties, powers to other officers.
Tend to hold the reins.
Absolutely. They retain ultimate oversight. They're not divested of the power, is the legal term. They can even step in and change decisions made by those they delegated to.
That makes sense. Ensures consistency, accountability.
Exactly. Critical for a nationwide system.
So with that centralized power, who exactly does this act cover? Is it just for South African citizens, or does it go wider?
It has a remarkably broad reach, which is important to understand its impact.
Okay.
The Act applies to all South African citizens. Simple enough, whether you're in the Republic or living outside the country.
So passport holders, basically, wherever they are.
Right. If you're a citizen, your birth, your death, it falls under this act. But, and this is key, it also includes persons who are not South African citizens, but who sojourn permanently or temporarily in the Republic for whatever purpose.
Wow, okay. So permanent residents, temporary workers, visitors, everyone.
Pretty much anyone living within South Africa's borders, even short-term. It ensures their vital events are also officially recorded and regulated, helps build that complete national picture.
So lifelong citizen or just passing through, your basic identity events are logged in this system. Okay, at its heart, this act is about creating and keeping official records. What does that mean practically? And who keeps this stuff safe? It's sensitive data.
The Director General, again. They hold this really critical role as the custodian of all documents relating to births and deaths.
The guardian of the nation's life story, in a way.
That's a good way to think about it. Every birth, every death, all those identity details, it all comes together centrally. It creates this huge interconnected web that underpins so much from voting to inheritance.
Right.
Now, for South African citizens, registration specifically means taking the details from the documents and putting them into the population register.
Master list.
Essentially, yes. The country's main list of all its citizens. Your official record of existence within South Africa.
Okay.
But there's a difference for non-citizens who are here temporarily. Their details don't go into that main population register.
Ah, okay, so how are they registered?
For them, the simple act of issuing a certificate is the registration. It's still official record keeping, just with different implications for being on that core national citizen database.
That makes perfect sense. A master record for citizens, separate but official records for others. Now, in our digital world, how are these vital documents managed? Verified? Are we still talking paper mountains?
Well, the Act has definitely moved with the times. There are provisions for efficiency, accuracy.
Like digital copies?
Exactly. Section 6 allows the Director General to reproduce documents, maybe electronically, and then destroy the paper originals.
And the digital version is legally the same.
It's deemed the original document or record. Certified copies of it are conclusive proof in court. So yes, it paves the way for digital systems. The Act also lets the DG verify, add to, or correct information.
So they can ask for proof if something seems off.
Yes, demand proof, investigate things. And if your certificate has wrong info, you actually have to hand it over or send it by registered mail for fixing within a certain time.
Put some responsibility on the individual, too.
It does. And of course, there are fees for various services. The DG figures those out with the Minister of Finance, and they get published.
Okay, before we get into the nitty-gritty of registering births and deaths, we need to talk definitions. Legal language can be tricky, but these terms are the foundation. They shape how the whole system works, right?
Really. Understanding these definitions unlocks how the Act operates day to day. Take biometrics.
Right, that's a modern one.
It's defined very broadly. Photos, fingerprints, hand measurements, even signature dynamics, retinal patterns, basically any unique physical or behavioral trait used to verify who you are.
Okay. And birth? Seems obvious, but legally?
Legally, a birth means the birth of a child born alive. This is critical, especially compared to stillborn.
What's the legal line there?
A child is stillborn if they had at least 26 weeks of intrauterine existence, so pregnancy duration, but showed no sign of life after complete birth.
That must be incredibly difficult, but the legal distinction matters.
It has huge implications for registration, for parents, for what support might be available or denied. It shows how the Act touches even the most sensitive moments. Then there's child born out of wedlock. The definition excludes kids whose parents married, either at conception or any time after that before the birth was finished.
Okay.
And marriage, the definition here is really inclusive now. It covers the Marriage Act, Customary Marriages Act, Civil Union Act, plus foreign marriages recognized here.
Reflects modern society.
It does. And then we have the obvious ones. Forename, surname, and major is 18 or older, minor is younger. These precise terms avoid confusion in a system built on personal details.
That definitely lays the groundwork. So let's talk about the start registering a new life. Amidst all the emotion of a birth, there's this crucial first step. How does the Act make sure every child gets on the record right away?
It starts with the notice of birth. Generally, parents or someone else prescribed if the parents can't have to give notice within 30 days of a live birth.
30 days, that's the window.
That's the standard window. And there's flexibility with surnames. You can register under the father's surname, the mother's, or a double-barreled surname combining both.
Gives families choices. What if they miss the 30 days?
Then it's late registration. It needs extra steps, meeting certain requirements. It's not impossible, just more involved.
Okay.
A really critical rule, though. No birth registration if the person dies before the notice of birth is given.
Right, sequence matters for records.
Exactly. And you can't register a birth without assigning both a forename and a surname. Basic identity details.
Makes sense.
Once it's done, that original birth certificate, it's considered solid evidence of the details in court. Prima facie evidence.
And you mentioned biometrics earlier, even at birth registration.
Yes, that's an interesting addition. Section 9(1)A allows the DG to potentially require biometrics, maybe fingerprints of the child and the parents, during the notice process.
A modern security measure right from day one.
Seems that way. Ensures accurate ID from the absolute start.
Okay, that covers the standard process.
Okay.
Now, what about children born out of wedlock? That can be sensitive, And the Act has specific rules here that are important for identity.
Yes, Section 10 deals with the notice of birth of child born out of wedlock. The default is registration under the mother's surname,
Okay.
or it can be registered under the father's surname if there's a joint request from the mother and the person who acknowledges paternity in writing right there in front of the official.
So joint agreement is needed for the father's surname initially.
Correct. And the Act also handles changes later on under Amendment of Birth Registration of Child Born Out of Wedlock.
Like if the parents marry later.
Exactly. If they marry after the birth is registered, they can apply to amend the record, basically to reflect the marriage. If they marry before giving notice, it's just registered as if they were married at birth. Simple. But a really crucial part is paternity acknowledgement later on. A father can apply to have his details added to the birth registration.
With the mother's consent.
Yes, with her consent. If she doesn't consent, the father's route is to apply to the High Court.
Ah, okay. For an order.
Right, for a declaratory order confirming he is the father and, importantly, dispensing with the mother's consent. This shows how this act links up with others, like the Children's Act. It's all about protecting the child's rights and identity.
Ensuring that legal parentage is clear. Okay. And what about children who can't rely on parents for registration? Say, an abandoned child or an orphan. Are there safety nets?
Yes, the Act covers those sad situations too. For abandoned or orphaned children, a social worker steps in. They give notice after an inquiry under the Children's Act.
So the system ensures they still get registered.
It does. And if a parent is found later and the initial details were wrong, the DG can correct them.
And births outside South Africa.
For citizens.
Also covered. Notice can be given to a South African diplomatic or consular mission abroad, or to a regional representative back in SA. This ensures citizens are registered even if born overseas. Keeps that link to the national record.
Okay, that seems comprehensive for births. Now let's shift to the other end of life's journey, death. It's inevitable, and this act regulates it meticulously. You mentioned the process differs based on cause of death.
That's right. The Act distinguishes procedures quite clearly. For a death due to natural causes, the standard process involves a medical practitioner certificate stating the cause of death.
A doctor confirms it was natural.
Usually. If a doctor wasn't present or isn't available, others who were present must give notice, and then a specific procedure follows to verify the circumstances.
Oh, okay.
Once the designated official is satisfied the death was natural, they issue a prescribed burial order. That's the key document to proceed.
But what if there's doubt? Good point. There's a safeguard. If there's reasonable doubt about it being natural causes, whether that doubt arises before or even after the burial order is issued, a police officer must be informed immediately.
To prevent suspicious deaths slipping through.
Exactly. It triggers a different process. Which brings us to death due to other than natural causes.
Like accidents or foul play.
Precisely. In those cases, there's usually an investigation under the Inquests Act. Once the medical practitioner involved certifies the body isn't needed for further examination.
Then what happens with registration?
A death register is completed, but without stating the cause of death at that point. Then a burial order is issued. The actual cause of death gets officially recorded later once the inquest finishes.
So for families going through this, that burial order seems like the critical piece of paper to move forward with arrangements.
It absolutely is. The act is very clear. No burial shall take place unless notice of the death or stillbirth has been given and a prescribed burial order has been issued.
And you need to give that order to the cemetery or crematorium.
Yes, it must be delivered to the person in charge of the burial place. It ensures every burial is officially sanctioned and recorded, maintains the integrity of the whole process, even during difficult times.
And what about those incredibly tragic situations like stillbirths? How does the Act handle those sensitively but officially?
Section 18 deals with stillbirth. If a medical practitioner was present or examines the body, they issue a certificate.
And if no doctor?
Then any person present makes a formal declaration to the official. That certificate or declaration serves as the notice.
And then a burial order?
Yes, if the official is satisfied it was indeed a stillbirth, a burial order is issued. But again, the same safeguard applies. If there's any reasonable doubt about whether the child was truly stillborn, the police must be informed before an order is issued. Or if one was issued, it gets canceled pending investigation.
Consistent checks.
Consistency is key. And just briefly, for deaths outside the Republic, registration involves a foreign death certificate. If the burial is happening in South Africa, officials at the port of entry are involved in issuing the burial order. It ties the process together across borders.
That covers the procedures well. Now, you mentioned an amendment about funeral undertakers. That feels like a practical addition.
It was a significant one, yes. Section 22A introduced the designation of funeral undertakers.
So they need official approval now.
Funeral parlors can apply to the DG for this designation. The DG keeps a public register. And they can remove undertakers for not complying with the rules, though only after giving them a chance to respond.
Fair process.
And the crucial part, only these designated funeral undertakers can legally handle the activities around registering deaths under this act.
Ah, so it professionalizes that service.
Exactly. It brings regulation and accountability to a very sensitive area. It's the state ensuring proper procedures when families are vulnerable. Quite fascinating, really.
And after all that, the final official document confirming a death.
Once the death is properly registered, according to all these rules, the Director General issues the prescribed death certificate. That formally closes the record.
Okay, so we've covered the initial registration for births and deaths. But life isn't static. Details change, circumstances evolve. Does the Act allow for updating these foundational records?
It does. It recognizes that identity isn't always fixed. There's amplification of birth registrations, for instance.
What's that?
If someone was registered before this act, maybe without a forename or surname, they can apply to have those added. Updating older records. Then there's alteration of forename. Both minors, through parents, and adults can apply to change their first name.
Okay, straightforward enough. What about surnames? That seems more complex, especially for kids.
It is. Section 25, alteration of surname of minor, is quite detailed. It outlines specific scenarios.
Like after a divorce and remarriage.
Yes. For example, if the mother remarries. Or if a child born out of wedlock is later acknowledged by the father. Or adoption. Each scenario has rules, often needing consent, like the father's written consent, or maybe a court order dispensing with it, or the new husband's consent if he takes the child in.
So it's not just a whim, it's a legal process.
Definitely. Designed to protect the child's identity and rights, ensure changes reflect legal realities and the child's best interests. You can also apply for a minor surname change for any other good and sufficient reason.
And for adults changing surnames, not through marriage.
Generally, Section 26 says no person can just assume another surname unless the DG authorizes it for a good and sufficient reason.
But there are exceptions.
Key exceptions, yes, mostly for women related to marriage. Assuming a husband's surname, resuming a previous one after divorce or widowhood, or adding a previous surname back.
And are these changes kept private?
Not usually for adults. Changes to forenames or surnames for majors are typically published in the Government Gazette for transparency. The main exception is for people under witness protection.
Okay, that makes sense. And you mentioned earlier a really forward-thinking provision, especially for 1992.
Yeah. Section 27A, alteration of sex description. This is a powerful example of the Act adapting.
How does it work?
If someone gets an application granted or a court order under the separate Alteration of Sex Description and Sex Status Act from 2003.
A different law entirely.
Correct. Then the Director General must change the sex description on their birth register. An amended birth certificate is then issued. It shows the system can reflect fundamental, legally recognized changes in identity.
A significant alignment with human rights and identity recognition.
Absolutely. And similarly, Section 27B covers recording of adoption in birth register, ensuring adoptions and related surname changes get properly recorded, linking back to the Children's Act and adoption orders.
So these records aren't just static snapshots, they can evolve. Okay, final area, privacy. With all this sensitive data being collected, how is it protected? Who gets to see it?
That's crucial, addressed in Section 29, secrecy. The default is confidentiality. Information from these records generally can't be published or shared, except for the Act's own purposes for court proceedings, or if another law requires it. That's the baseline protection.
But are there ways to access it?
Yes, there's a balance.
Yeah.
The DG can give info to other government departments for their official statutory needs.
Okay, interdepartmental sharing.
And they can also provide info to individuals who apply, but they need to fully explain why they need it.
And the DG decides.
Yes, the DG has to be satisfied that giving the info won't be an unreasonable disclosure of personal information under the Promotion of Access to Information Act, PAIA, or alternatively, if it's needed to protect the person's own rights or interests, or if it's genuinely in the public interest.
So it's a careful balancing act.
Yeah.
Privacy versus legitimate needs for information.
Exactly. Individual privacy versus state functions and sometimes the public interest.
Sounds like a tricky line to walk, but necessary. And finally, what happens if people don't follow these rules? Making false statements, messing with records? Are there consequences?
Oh, absolutely. The Act has teeth. Section 31 covers offenses, penalties, and evidence.
Like what kind of offenses?
Failing to give required info, making false statements, intentionally losing or damaging records, forging documents, even funeral undertakers charging excessive fees, or someone not handing over an incorrect certificate when asked.
And the penalties.
They can be severe. Fines or imprisonment up to 15 years or potentially both.
15 years, wow.
It underscores how seriously the state takes the integrity of these records. There's even a presumption if you're found with a forged certificate obtained illegally, the burden can shift to you to prove you weren't involved in the forgery.
They are foundational records, so it makes sense they're heavily protected.
Precisely. They underpin so much of our legal and administrative identity.
Wow. So listening to all this, you can really see how the Births and Deaths Registration Act, Act 51 of 1992, is so much more than just, bureaucratic paperwork. It's truly a foundational legal document. It underpins identity, lineage, the whole structure of how society keeps track. It really shows how law touches every single part of our lives, literally from birth.
And you've seen, hopefully, how this act, which seems straightforward on the surface, is actually this complex tapestry, full of legal provisions, all designed to ensure accuracy, protect rights, and, importantly, adapt as society changes. Understanding its nuances, like we've tried to do today, gives you invaluable insight into how these legal frameworks govern our personal lives, our public lives. They offer protection, but also essential structure.
So here's something to think about as we wrap up. We've seen how the Act has evolved, the gender-neutral language, adding sex description alterations. Considering that constant evolution, how might future technology think more sophisticated biometrics, maybe AI analyzing records, or even ongoing shifts in how we understand identity and family? How might those things continue to shape this foundational law? What new challenges, what new opportunities for managing identity might pop up that we haven't even thought of yet?